there is something that we constantly hear from our new clients who had previously been represented by other lawyers or had called other lawyers for advice, and that is this. You have an injured worker that is very severely injured, and these lawyers say, well, if I'm handling your comp case, I do not want you to apply for Social Security disability. What you need to realize is that lawyer is giving you that advice not because it's the best advice for you, but because once you get qualified for Social Security disability income, the lawyers then got to deal with several concepts. Two of the main ones are what are called conditional payments by Medicare, and also what is known as a Medicare set-aside trust that you have to do in order to preserve your Medicare rights into the future. That means that if a lawyer is handling all that and he has all this additional work to do, he's got to do more work, it's more time consuming, it's aggravating, and his profit margin is going to be less. But here's what I want everybody to know. If you are a significantly injured workers' compensation claimant and you have the ability to qualify for Social Security disability income, you should do so. Here are just some of the reasons. First, it puts you in what I call the safe harbor. Now, not only do you have your workers' comp case, but you got Social Security disability income, and then you're going to qualify for Medicare after 24 months, the 25th month from the date that Social Security finds your date of disability. So now you're in a safe harbor. You have a resource that you didn't have before. The other thing that happens is the comp carrier then has to fund the Medicare set-aside trust to settle your case. Now, if you're trying to maximize your total recovery from all the resources available to you, the way to do that is to first qualify for Social Security disability income. That will qualify you for Medicare once the adequate time has gone by. Then you have to get a Medicare set-aside trust set up so that it protects your right to Medicare in the future. Now you're in the safe harbor. It makes it more economically feasible for you and safer for you to do what you want to do, which is settle with the workers' comp insurance company and quit having to deal with them. Now, it may not be the best for me to have to do all that extra work, but it's the best for my client. So my pet peeve for today is that lawyers that tell injured workers they shouldn't apply for Social Security disability income, and I'm going to tell you one more reason. As you don't work, every quarter of the year that goes by, you lose a quarter of coverage. We see many times workers that have been told not to apply for Social Security disability, and by the time they get to us, they have now lost quarters because they no longer have what Social Security refers to as an adequate quarters of coverage for insured status. So instead of trying to prove that you're disabled today, we're trying to prove that you were disabled years ago, and that evidence may be gone. That evidence may not have been preserved. And it's much harder to prove you were disabled years ago before you lost your quarters of coverage. So there are many reasons to apply for Social Security disability income when you have a workers' comp case, and those are just a couple of them. So if you want to maximize your recovery, apply for Social Security disability. Don't wait until you have lost current insured status because you now have inadequate numbers of quarters of coverage. I tell all of our clients the standing rule is, unless we tell you otherwise, you should always apply for Social Security disability income benefits no later than the 3rd year anniversary of your on-the-job injury. Now, there are reasons I use the 3 years, and sometimes we may give different advice, but that issue is too complicated to not discuss in person with someone.